I think that we can go ahead and get started. Looks like the slowed down just a little bit, but I'm sure that more people will be coming in. Just want to welcome everybody here. My name is Kelly Olson. I'm the policy manager with the Civil Survival Project. And tonight we are hosting April is Second Chance Month. And so we wanted to talk about LFOs tonight, which, as if you've tuned in, you probably know a little bit about LFOs and what a burden they are. So we just wanted to talk a little bit about that tonight. Tonight we have Representative Tara Simmons here who's going to talk. We also have attorneys Hannah Werner and Nick Allen from Columbia Legal Services. We have Robert Boyer here who's going to talk a little bit about his personal experience. And we have our own Jacob Kuykendall from Civil Survival Project, the Reentry Legal Aid Project. So I'm going to go ahead and turn it over to Tara. And Tara, I think we're excited to have you here tonight. I know that session just ended Sunday, and we wanted to give you just an opportunity to talk a little bit about what was that like, and just share a little bit with us, and then we'll jump into a little bit more of the LFO stuff, but wanted to hear a little bit about session and what it was like and some of the wins.
Thank you so much, Kelly. Thank you everyone for coming today. It is great to celebrate Second Chance Month. And yes, I just finished my first session as the first and only formerly incarcerated person in the legislature. And it was definitely a learning experience full of wins. I'm going to try to focus on the wins, although it ended in a very heartbreaking way for me. And today's the first day I haven't cried in 10 days, but we won't dwell on that because, we're going to really celebrate Second Chance Month and the wins. And, I want to say it was definitely like a Disneyland for policy nerds, though. I had never imagined the amount of staff support that we have as legislators to draft policies, to help strategize with us, to do communications and things like that. It was really great. It was very difficult, I think, as being the only person with lived experience and having to constantly kind of like reshare your trauma in order to illuminate conversations, because people approach the criminal justice work often with great intentions and with data, but they don't really understand the lived experiences. And so, for example, debating the drug policy and the Blake decision happened in February 25th. And, people were talking about, well, how about if 1 gram is, not a crime, but 3 grams is, and like having to explain, when I purchased my drugs and how much I had, and like to try to help them understand these things and just talk about the traumatizing experience of being incarcerated, and really trying to push them to not do harmful things to people who are suffering with, behavioral health disorders. But with my one loss, I did get a lot of wins. And I got some other losses too, House Bill 1282 and 1412, which we'll talk about here in a minute. But I did get some good wins, and overall session was really great. If you haven't been able to see from a high level perspective, people that have been incarcerated are often poor and people of color and already marginalized in so many ways. And we did some big things like passing capital gains tax and passing a working families tax credit, which is, fixing our tax code. And we passed a lot of environmental justice bills, and our budget is just beautiful, and it really invests in housing and behavioral health and so many things that our communities need. But specifically to folks reentering, we did pass the Voting Rights Restoration Bill, which I know a lot of people on this call or the Zoom worked on. So now folks can vote as soon as you leave prison, even if you're in work release. And that's, part of reducing stigma and welcoming people home and inviting them back into our communities. We did finally get retroactive 3 strikes bill through, which is robbery in the second degree. So about 114 people are coming home who were sentenced to life without parole from robbery in the second degree. That work took about 10 years. And 2 years ago, we passed a bill making robbery in the second degree not a third strike going forward. And this bill 2 years later was to, go back and get the 114 people that are still in on that robbery in the second. We passed a bill to make sure that people's Medicaid doesn't lapse when they go into jail. And that's important because if you lose your Medicaid and you come out of jail and you need to get, support and your medications and you're not on Medicaid and you're dropped from the rolls, there's a, huge break in the continuum of care. I got another bill through, House Bill 1411, which is chipping away at the Department of Social and Health Services disqualifying background list, which prevents people with criminal histories from becoming in-home care providers. I really want to continue to work on employment opportunities for people with conviction records and particularly healthcare jobs. A lot of the wins that I got were in the budget. One really great thing is I got $5 million to create a fund that community-based organizations doing reentry can apply to. This is going to be great. It's the first time ever that the state has made a significant investment in community-based reentry programs. Usually all of the money just goes to the Department of Corrections and they kind of administer the money for people reentering. And now we will have $5 million under the Department of Commerce where organizations that help people reenter can apply for grants. I really hope it goes to organizations led by and for formerly incarcerated people, and we get that lived experience and peer-driven work, into those funds. I also got $750,000 for my local tribe, which has a welcome home project that is a human dignity model reentry program. And I got $200,000 for a reentry navigator at my local community college, Olympic College, $11 million for public defenders to help people vacate or resentence for the drug possession statute, the Blake decision. So $11 million for public defenders, and the prosecutors got nothing. So that was great. And $1.2 million for civil legal aid to help people vacate their drug possession charges. So those are, some of the high levels. One thing that, didn't pass, which I was really sad about, was the LFO bill that we're going to talk more about here. That was House Bill 1412. And really, Hannah and Nick and Kelly and Robert, everybody on this call that's going to speak was leading that effort and drafted the bill and was working so hard. And so it was really unfortunate that didn't pass, but we have more hope for next year. And so we're going to tell you more about that bill now. I think we're going to play a video and we'll be talking about that throughout the rest of this evening. Thank you.
Great, thank you, Representative Simmons.
Yeah, sure. Would it be helpful to give an overview of the bill and kind of the?
Yes, please. That'd be great.
Okay. Well, just to give a little bit of background, so I'm sure many of you on this call were instrumental in the passage a couple of years ago by the state legislature of House Bill 1783. And House Bill 1783 was the kind of culmination of many years of work to educate legislators, the legal community, about the impact that legal financial obligations are having on people, and the starting point for some of the changes that needed to be made legislatively to reduce the impact that legal financial obligations have, particularly on successful reintegration back into the community. And so there was a group of about 6 or 7 major provisions that were included in that bill to do everything from creating an indigency standard for whether or not LFOs could be imposed or waived at sentencing, whether or not somebody could be sanctioned for failure to pay. There were provisions put in to waive interest altogether, eliminate interest on non-restitution LFOs, so the costs, the fees, the fines. Increased opportunities for conversion of legal financial obligations to community service, and also the elimination of the mandatory nature of some legal financial obligations that previously courts had to impose at sentencing. What 1783 did was require that courts not impose some of those legal financial obligations if they, at the time of sentencing, meet this this indigency standard. So really, a lot of good and positive reform efforts around legal financial obligations that took place in 2018. Of course, that was only a first step, and I know, like what we've heard, I'm sure what others of you have heard and experienced with regards to LFO since the passage of 1783 shows that there's still a lot of gaps out there. 1783 by no means was a perfect fix. Like I mentioned, it's just a first step in what I hope is many towards completely eliminating the burden of legal financial obligations on people coming through the criminal legal system. And so over the years, those gaps have been identified and categorized. And this year, there was an opportunity to revisit legal financial obligation reform again. And that was primarily done through the creation of the Washington State Criminal Sentencing Task Force, of which both Representative Simmons and I served on. And this is looking big picture at ways to change Washington's sentencing system. As a part of this, the group was broken down into two subgroups, one that focused primarily on sentencing effectiveness, and another one that focused on reentry. And the group that was put together around reentry highlighted legal financial obligations as one of the issues that should be addressed. So over the course of probably, I don't know, 6 to 8 months, along with a couple of other issues that were relevant to the reentry subgroup, we worked on what kind of things could and should be changed around LFOs. And having that kind of list of second step reform efforts in our back pocket, those were discussed and debated before the sentencing task force. And as a result, we were able to, as a full task force, come to full consensus on, I want to say, like 7 or 8 legal financial obligation related recommendations, and partial consensus on another recommendation. What happened after that is that Representative Simmons introduced an omnibus bill that basically took a lot of these recommendations, combined them into one bill, which was introduced as House Bill 1412. And 1412 would do a number of different things that currently are not allowed under law related to legal financial obligations. Probably the most important of these relates to restitution. In the past, restitution has kind of been off the board as a discussion topic when it comes to legal financial obligations. But as we all know, in many situations, restitution can comprise of the majority of the legal financial obligation outstanding debt. In some courts, you might see they will impose, the mandatories, so like the $500 victim penalty assessment, but then someone will be stuck with a $30,000 restitution bill that is accruing interest at 12% a year from the date of judgment. What was accepted as a recommendation by the task force and included in 1412 is a provision that would allow individuals who had received restitution to be able to go back before the court and ask for a waiver of that restitution, provided it was owed to an entity and not an individual. And that was kind of a compromise position. It's tough to make the argument that a person who is a direct individual victim isn't entitled to compensation for their losses. And then on top of that, what we've seen over the years is that the majority of these large restitution orders oftentimes owed to insurance companies, hospitals, entities, and these are the big amounts. And so this bill would allow individuals to go back and ask for a waiver of this restitution, and the court would have the discretion to waive that, provided the person lacked the current or future ability to pay. Like the court makes that finding that they lack the current or future ability to pay, the court could get rid of those restitution amounts. Similarly, and this was a provision that was pushed pretty significantly by the Superior Court Judges Association. And this also relates to restitution, would allow the court at sentencing to waive the interest on restitution. So right now, no interest accrues on costs, fees, or fines. You get the principal and you have to pay the principal off. But it still accrues at 12% a year on restitution. And what this bill would do is allow, at the time of sentencing, the defendant to say, court, I can't afford to pay this restitution. It doesn't serve any purpose. And the court could go through a number of factors that were set out in the bill and make a decision not to have interest accrue on those obligations. Another provision that was eventually taken out of the bill through an amendment was to automatically waive interest on non-restitution obligations that accrued prior to the effective date of 1783. So what I mean by that is the court got rid of interest on costs, fees, and fines, but it was really only prospective from the date that bill became effective in law in June of 2018. All of the interest that accrued up until that date still remains in place. And what a person has to do in order to get rid of that interest is file a motion with the court, which the court has to grant, but it's just an added administrative barrier that, first you'd have to know that law exists, and then second have to go through that motion filing process to get the relief. And what was included in the bill was to just, make that an automatic waiver looking back, have the clerk's offices, push a button to get rid of all of that interest up until that point, so that would no longer remain in place. Another piece was to expand eligibility to request relief from certain types of LFOs and interest to people who are still serving their terms of total confinement in prison. So right now under the law, there are restrictions on who can apply for relief from costs and from that interest that I talked about earlier. You can't file a motion for that past interest relief until you've been released from total confinement. This bill would have struck those restrictions and would allow for individuals while still in prison to ask for relief from costs, from discretionary costs, from costs that were imposed by the appellate courts, by interest that accrued prior to the effective date on interest while they're still incarcerated. A couple of other pieces here that I just want to hit on, and please let me know if I need to wrap up quickly. But one was a provision that explicitly grants statutory authority to courts to waive fines. So right now, what you have under statute is that anybody who receives what's known as discretionary costs, so a lot of folks get like the cost of their public defender or warrant fees. If they get those, they can go back before the court at any time after release from total confinement and ask for a waiver of those costs. There's not a similar provision, however, if you have fines. And while there is limited statutory guidance that would allow courts to do things like suspend the fines, there's nothing explicitly in statute that allows the courts to do the same thing with fines as they do with costs. And so this 1412 would allow a person, after a fine has been imposed, to go back before the court and ask for a waiver of those fines, provided they show they meet, that the fines create a manifest hardship for them, which is defined by statute as somebody who, like, either his income is at or below 125% of the federal poverty guidelines, is receiving certain public benefits, et cetera. The reason for that is because what we've seen with a lot of folks who go back after the fact and ask for waiver is that the court will get rid of costs, but it'll leave the fines in place because the court will say, I don't have any authority to get rid of those fines. And so we heard that from people over the years that said, look, I was able to go back before what was somewhat sympathetic court, but I've still got all of these LFOs in place that the court says they don't have any statutory authority to waive. There's three more things that were included in the bill. One is reinstating the court's expiration on the court's jurisdiction to collect legal financial obligations that were imposed for felony offenses. So right now under the law, if you have LFOs that were imposed for offenses that were committed after July of 2000, though the court's jurisdiction to collect those never expires. So I could have legal financial obligations 40 years from now, and technically the court could still come back, issue a warrant for my arrest for failure to pay. I could have to come back before the court, explain my failure to pay until those LFOs are gone. What used to happen is that the court's jurisdiction would be in effect for 10 years from the date that person received the LFOs, or 10 years from the date that person was released from prison. And the court could add an additional 10 years, but the court's jurisdiction would extend no more than 20 years from that date of judgment or that date of release from total confinement, which is still a long time, but it allows for some finality. What 1412 would do is reinstate that provision so that there would be some end to the court's jurisdiction to collect legal financial obligations rather than having it just continue indefinitely for the rest of people's lives. And then the last two things are that in 1783, that bill I talked about from a few years ago, it said that there used to be these three general mandatory legal financial obligations. You get the victim penalty assessment, the criminal filing fee, and the DNA collection fee. Everybody that was coming through a Washington State Superior Court would get those $800 in legal financial obligations because the court didn't have any jurisdiction to discretion to waive those. What the legislature did back in 2018 was say for the criminal filing fee, the court cannot impose that if the person is indigent, according to that standard that I talked about earlier. Similarly, for the DNA collection fee, it said you can't impose but one DNA collection fee. If you've already collected someone's DNA, you can't go back and charge the person for another DNA collection fee. But that only works moving forward. And so what this bill would do is allow people who had DNA collection fees and criminal filing fees in place prior to the effective date of 1783 to go back before the court and ask for a waiver of the criminal filing fee based on their indigence, and I also asked the court to get rid of all but one DNA collection fee, which the court would have to grant. And then the final piece, and this was the partial consensus recommendation that came out of the Criminal Sentencing Task Force and was probably the most contentious of all of the provisions in 1412, is this victim penalty assessment. The VPA is a mandatory $500 legal financial obligation that has to be imposed for every criminal judgment and sentence in a Washington State Superior Court. And it is not waivable, it's not modifiable, it's not convertible. It is imposed regardless of if you have a victim or not. It's not restitution. It goes to a fund that supports, that's maintained by prosecutors' offices in each local jurisdiction to support victim and witness testimony. And what we were able to talk about in the criminal sentencing task force is that because this thing is not waivable and because it's imposed for every criminal judgment and sentence, what you have is folks that have 5 of these. So they have $4,000 that or $3,500 or $2,500. That's nothing but victim penalty assessments that they can't do anything about. Why won't you allow an individual after sentencing, if they can't afford to pay this, to go back before a court like you do with most other legal financial obligations? If you can show you're indigent, the court can get rid of that victim penalty assessment. And that's what this bill would have allowed for. So that is a pretty wide range of issues and gaps to fill through 1412. There was, I think, there was pushback from counties and cities who argued that this was going to cost too much to the local jurisdictions. I think the pushback to that is you're talking about uncollectible funds. And so you're just removing money off the books. You're not actually removing monies that are collected. If a court's already found this person has no ability to pay, that means they weren't going to pay into this in the first place. But regardless of that, that was a challenge. Similar, and that was the same issue kind of with the victim penalty assessment as well. The bill got out of I believe it got out of the policy committee and it got out of the fiscal committee, and then died in rules, but not due at all to any lack of effort on the part of Representative Simmons and on the part of advocates trying to push forward with the next phase of legal financial obligation reform. Just briefly speaking, I think there's still opportunities going into next year. I think that, for instance, the media piece that was put together, I think it was in the Seattle Times, where there was the kind of thing that Representative Simmons is talking about, someone actually talking about the impact of legal financial obligations on them, rather than, kind of my sterile overview that I'm giving here about how legal financial obligations work. I think is much more effective, not only for figuring out that legal financial obligation reform needs to take place, and a second step, but how it should be done and why it's urgent. And so I'm hopeful, going into next year, that we'll see some of the same things that happened with the 1783 advocacy efforts, where it wasn't the legal advocates that were the primary folks leading that work, but that it really was impacted communities, people with legal financial obligations, and their families, which I think is oftentimes left out of the picture, that this isn't just an impact on one individual, this is an impact on families and communities. And yeah, thankful that we had such a good and committed sponsor to this, and that the fight is not over, and we will continue going into next year to work towards this next phase of LFO reform. So I hope that's a somewhat decent overview of what's been going on here, and happy to answer any questions.
Yes, thank you, Nick. And also thank you for in with our technical difficulties. We had some video queued up to play. I think that we might go ahead and to Tara, if you kind of want to give some perspective from your side, especially from the inside. I know Nick went over some of happened, but I'd love your perspective from you as well.
Yeah, thank you, Kelly. So as a new legislator, I've learned a lot about what can slow down your desires to get change done. And oftentimes, unfortunately, it falls on politics and partisanship. And, if you really want to get something done, you try your hardest to get Republicans to support your idea. And unfortunately, I wasn't able to get any Republican to co-sponsor the bill at the beginning. And we dropped it, probably like 3 weeks into session. And, your first stop is your policy committee. And fortunately, I'm the vice chair of Civil Rights and Judiciary. So we definitely had a hearing, and that was great. But my Republican colleagues really hated this idea, and they introduced, I think, 12 amendments. And so, you know, all of that takes a lot of time. And so time is like the biggest challenge in the legislature. We only have so much time. And because they dropped 12 amendments, you know, fortunately, we were able to make time in the policy committee and bat down, I think, 11 of the 12 amendments. We took one to try to build some, you know, relationship and some, you know, collaboration, and it wasn't detrimental to our effort. And so we took one, and then we got it out on party lines. All Democrats voting yes, all Republicans voting no, do not pass. And then we went to the Appropriations Committee. Unfortunately, my chair, who's my seatmate, Representative Drew Hansen, is on the Appropriations Committee. So that really helped, and he got it out of appropriations again on party lines. But whenever you know, getting to the floor and into the Rules Committee, which I serve on the Rules Committee, but I wasn't able to pull it out because it hadn't caught up yet. It was like one of the last bills out of appropriations, and it wasn't in rules when we were meeting. And thinking about how much time we have on the floor to pass bills, you know, this one would have taken a lot of time because there was a lot of amendments in the policy committee. Plus, it was hotly contested by Republicans, prosecutors, and the counties. And you know, at the end of the day, you know, the Speaker of the House, who used to be the chair of Civil Rights and Judiciary and really likes this bill, you know, basically at the end of the day, it was because of the county's opposition, because this session we had a lot of bills that were going to potentially have an impact on local county budgets. And although I don't think this one would at all, or very minimal, you know, it was kind of, you know, they could only do so many that were going to impact the local county budgets. And that was the reason I was given why it couldn't proceed, plus the amount of floor time it would take out. However, now for next year, it's sitting in rules and it's going to stay there. And it will be my first poll when we go back to Rules Committee. But in the meantime, we also might have created a new path, which is really great. Because of the media with the Seattle Times, the person who was featured is actually a relative of a Republican senator, Senator Sheldon. He's actually technically a Democrat, but he caucuses with the Republicans and votes with the Republicans, so it doesn't matter. Anyway, he was so inspired and literally called me like in tears. And 2 days before the end of the House of Origin cutoff, he was reaching out to all kinds of senators and House members and my leadership and everybody trying to get that bill through. He has definitely taken up the cause and believes in second chances, believes in his family member, and you know, said really nice things to me too. And so he introduced our bill in the Senate, and we're going to meet with him soon and think about strategy for next year. And at the end of the day, I don't care if my name's on it. I will give this bill to him and let him lead it, as long as he will make sure and fight for it and not concede on certain policies in the bill. But if he gets it through the Senate, it has to come over to the House and go through Civil Rights and Judiciary, so we can make changes there too. So I'm really optimistic for it next year. And then Hannah, who's on the call, I'm going to ask Hannah to talk about this. My husband's remodeling the house. Anyway, yeah, I'll just turn it over to Hannah. She had a really bright idea at the really at the last minute to get a study in the budget, and we did get the study in and got it funded. So I'll let Hannah talk about the study.
Thank you, Representative Simmons. So hi, everyone. I'm Hannah Warner. I'm an attorney with Columbia Legal Services. And as Rep. Simmons mentioned, we got a great win in the budget this past session in the form of a budget proviso. And the budget proviso is a specific provision in the final approved budget that will fund a study on LFOs. And this study is important because, as folks have mentioned, one obstacle that we faced during advocacy efforts on House Bill 1412 was significant opposition from the counties. And we faced an obstacle in countering that opposition because we lack current data on LFO collection rates throughout the state. And certain county and court programs are funded through the collection of LFOs. And this creates an unfortunate incentive for local governments to oppose any changes to the LFO system. And as Rep. Simmons and Nick have mentioned, the counties this past session testified that the bill would have or could have a negative impact on their budgets. And so currently we don't have data on the annual amounts of LFOs imposed and the amounts of LFOs that are collected across the state. And so without this data, we couldn't definitively show a number of projected revenue loss that the counties could expect. And our argument has been that this would be a minor impact on local budgets because counties simply haven't been collecting a lot of money from people who don't have the ability to pay. And so if House Bill 1412 were to pass, local government shouldn't see a significant loss of revenue. And the budget proviso allocates $200,000 in funding for a study and that directs the Washington State Institute for Public Policy to gather data on LFO collection rates and to provide recommendations to the legislature for ways to de-link funding for courts and for other county and local programs from the collection of LFOs, as well as recommendations to the legislature on how to provide this local funding through other means so that we're not funding the courts and these programs on the backs of poor people. And we will receive an initial report in December of this year, 2021, and then the final report in December of 2022. And we're excited because this study will keep momentum on the bill moving forward into next session and hopefully provide us with some valuable data to use during our advocacy efforts in the interim and next session. So thank you.
Great, thank you so much, Hannah. I don't know, we're gonna move on to Rob here in a second, unless Nick Tara wants to add anything before we move on. Any last, okay. So one of the things that we just wanted to highlight and let people know, Rob here was one of the people who testified at the hearing and did a great job. But we know that the people in the community are suffering. And so we're gonna hear a little bit about Rob's story. And again, thank you, Rob, for being here, and thank you for coming and testifying. Go ahead and hand it over to you, and you'll share a little bit about how the LFOs have impacted you in your life and how it is that you've worked to move forward.
Absolutely. Hi, everybody. Thanks for having me out and being part of this. My name is Robert Boyer, and I'm a journeyman waterproofer in the local union. I'm also a father, a grandfather, a husband, a friend of many in the community. In 2013, I was convicted of over 167 counts of obtaining narcotic prescriptions by fraud. In addition to the time I was convicted or sentenced to serve in prison, I was also given restitution of $147,000 payable to multiple hospitals. And now the restitution is currently $259,000. Every time I take a step forward, I was pushed back. I'd find a job, find housing, and people would find out about my crimes, and I would have to leave. I was able to rent an apartment, but then my wages were garnished, and I could no longer afford the rent. I have done everything I can to avoid going back to this life I used to live, and that includes trying to pay these fees. One of my former employers paid part of my wages under the table and part of it on paper, so I could make restitution payments and have money to survive. I have slept outside on the ground. I have eaten out of garbage cans, but I still stayed clean and sober. I've carried all my belongings around in a backpack and remained clean and sober, and slept in many places that, just stay warm. A few years ago, I filed a bankruptcy to stop the garnishments, and that was just temporarily because my Chapter 13 case is going to be ending in about 3 weeks. And now I'm faced with creating a plan to pay these to avoid garnishments and worse, warrants, and possibly jail time. I would love to help my son with college and loans for his graduate school, but I cannot. I would love to own a home, but because of my restitution, I can't be put on the title. I have opportunities to work close to home, but I can't because it requires a financial background check that I cannot pass. Almost 2 years ago, I spoke at the 61st Judicial Conference, and thanks to Silver Survival, I worked with Judge Linda Covert on a presentation She looked at my case and said, quote, according to my calculations, it would take you 122 and a half years to pay off the principal, and that's not including the interest. When I speak at these events like these, it brings up a lot of emotions. It hurts. I get sad. I kind of go into a little lull for a little bit because, you know, I feel what professional punishment is. I feel that no matter what, I just settle, and I don't want to. I believe there's something more. Every day I get up and I try to do the next right thing, yet there are always these fears and fees hanging over my head. I'm not the only one out there, and I believe and I hope, which I have a lot of hope. Even though I often feel my case is hopeless, my hope is for the future of people that come behind me. There needs to be relief for people who have served their time and are working so hard to be contributing members of society. You know, not disenfranchised no more. I just want to live. I'm accountable for everything I've done. I just want help, and I want to help others. That's all I have to say. Thanks for having me.
Thank you, Robert, so much sharing that. Resonates with a lot of the people on here, including myself. And so to kind of close out the session, what we to do is we Jacob here, and super excited that Jacob is here. So Civil Survival has an entry legal aid project, and I'm going to let Jacob introduce that and talk a little bit about it. I know earlier there was a question about how to get any kind of help. So I'm going to hand it over to Jacob, and he'll kind of explain the things that we are doing, what is available, and I'll let him take it from here.
Thanks, Kelly. Hey everyone, my name is Jacob Kuykendall. I'm a staff attorney for the Reentry Legal Aid Project, which is the legal aid program in civil survival. To give you a little history about what we do and the work that RLAP does with civil survival, this program is only been around for about a year. The idea is to provide legal aid support and information and advice, and when possible, direct legal help to folks who are struggling with reentry issues anywhere in the state of Washington. So covering kind of, well, what do we do as part of that? We have resources available on the Civil Survival website. I saw someone in the chat asking about information about LFOs and about vacating. I would say go to civilsurvival.org. That's a good place to start. We help a handful of clients directly with a number of reentry issues that I'll talk about in a second. We're building out a robust volunteer attorney program. So, you know, we're still a pretty small legal aid program, but we've got a lot of support from attorneys all around the state who we can either refer clients to, transfer folks who might be able to get help that way. And we also have volunteers who are just donating their time to represent folks who need help. We're also doing a lot of systems level work. So, you know, you've heard from a handful of folks on this panel about work they're doing with the legislature and and around policy. One thing that RLAP is doing is working with like judges and court clerks and people involved in the court systems all around the state to try and build better systems for helping folks with reentry, making that more accessible to people who don't have an attorney but still need help. So to give you a sense of like what kind of services we provide, the big ones that we help folks with are vacating eligible convictions, which means folks who have convictions on their background reports, like you apply for a job or you go apply for housing and you're being denied because something's showing up when they run a background check on you. There are some of those are eligible to be removed, basically mark them private. So we can help folks do that when they're eligible. We also help a lot of folks waive legal fines when they're eligible for that as well. You know, Nick had mentioned that there are some fines that are not eligible to be waived, and there's some that are. So we can help folks figure out whether they're eligible to waive them. And if they are eligible, then go on our waiting list, be paired with one of these volunteer attorneys, or be helped with a civil survival attorney directly. We also have the ability to help with a lot of other reentry issues when that's effective. So things like people are being denied licenses because of convictions on their record, sex offender registration relief. I've even helped a couple folks who had just sort of weird reentry issues because they had convictions on their record that was causing barriers to getting a job. You know, right now we've been understaffed for a few months. So our waiting list is pretty long, but we've just hired another staff attorney. So we're looking to clear out our current waiting list by June. So my suggestion is if you are in that situation, or you know someone who might need this help, reach out to us, go to the Civil Survival website and go to the contact page. Send us a message and we will figure out if there's anything we can do and add you to our waiting list or pair you with a volunteer attorney. We're really trying to be a resource to anyone in the state who is dealing with these issues, who's low income, couldn't afford an attorney themselves. That's a really quick version of all the different things we're working on, but I'm happy to answer questions as well if folks have them.
Great, thank you, Jacob, for sharing. So we are at a place for questions and answers. So I know there were some questions in the chat. If people try unmuting themselves and asking, or putting them in the chat.
Hi, Kelly, thanks. Bruce Glant here. Hi to all those who I know. Tara, I want to congratulate you on a phenomenal rookie year. Congratulations and thank you for all you did. I do have a question, Jacob, Representative Simmons, and Mr. Allen as well. Is there any discussion about doing away with the sex offender registry? Research that I hear and from people who have been involved in working on this for a long time say that the Justice Department itself says that the registry doesn't work. So is there talk about that?
I've definitely heard that, and I personally think that it definitely needs to have some reform. I have not heard of a legislative proposal yet. I think that it would require a lot more education in the legislature to pass something like that. I want to ask Nick Allen, in your hat as being on the criminal sentencing task force, has there been any conversation about that?
No, that has not come up. And I know that Mr. Glant joins those task force discussions pretty regularly. And I know has made similar comments there, and but it has not come up during those discussions at this point.
That I'm just wondering if that's something that maybe could be put forth next session, and I'd like to talk to you about that, Representative Simmons, about a WISP study on that for the state of Washington. I mean, it originated here. It'd be nice if it could end here.
Sounds like a good idea.
Thank you.
And just quickly, I do believe there was a juvenile sex offender registration bill that was introduced this year. I don't know where it went. I think it was 5123 might have been the bill. And I just, sometimes efforts often like that often start in the juvenile realm before folks start to see, well, the sky is not falling, and expand it out to adults. So it might be a bill that you want to review if you haven't seen that already.
Yeah, I haven't, and I will, and I'll talk to you about that well, I'd like to talk to you, Nick, as well as certainly Representative Simmons. And I am going to be getting in touch with you in the next day or so. Thank you.
And this is Connie from Spokane, and I'd kind of like to second that because I have two clients that are now having to be lifetime registrants. One was the process started when he was 9 years old, and the other he was 13. As a mother of 3 sons, I'm sorry. That's kind of what boys do. You show me yours, I'll show you mine, sort of thing. And unless they've had something that really gets in early to explain what is appropriate and what is not, we're seeing children being affected and convicted that for this lifetime when they were just being more curious. I'm not talking about actual attacks, but I mean just, exposure sort of things. So if we could maybe start with baby steps that look at youth, that might be inroads.
Thanks, Connie. Are there any other questions?
Can you hear me?
Just barely.
I'll try and speak up.
That's
So I just wanted to mention that the Department of Corrections had proposed a 50% budget cut when Governor Inslee asked them to just look at it, and they suggested removing the lifetime supervision for sex offenders and reducing actually all supervision down from 3 to 5 to 10 years. Has that even come up again? I didn't know if the department got all of their budget that they asked for or not, because it was recommended for the legislature to take that up based on a Institute of Public Policy study that says supervision is really ineffective after 5 years.
Yeah, unfortunately, the DOC proposals that were created during a time where we thought we were going to have a budget shortfall, died. Both the tolling on community custody was one of them, and then my bill, which was earned early release retroactively for all people to go up to 33%, also died. I think there was a time in the summer where the governor asked all of the agency heads to go through this budget exercise and reduce their budget by 15%. And we ended up having a surplus of money. Actually, the forecast continued to rise, plus the federal government sent us a large amount. And so those ideas weren't necessarily prioritized, which was very disappointing. It was another heartbreak for me in session, was to not be able to advance my earned early release 1282 out of appropriations. And so, unfortunately, what I am, learning in here is like there needs to be a lot more education in the common mainstream about the justice system to get more people to kind of demand change. We got, for example, we got 10 or 11 police accountability bills through this session, which is great, but that's because of what happened in 2020 and really bringing to the surface the role of policing. That has not happened yet for justice system reform issues. And so I'm going to be thinking through like, how can we, this is a huge, battle to reform our justice system in all these ways. Unless, there's 147 legislators and there's probably about, 10 that are, prioritizing criminal justice in some ways, maybe even less than that. And the rest are in their environmental worlds and in their like workers' rights worlds and, all these other things, until it kind of becomes more of a mainstream priority. It's very, very hard to get any of these things through.
Thank you, Chara.
Yeah.
Representative Simmons. Okay. Other questions? Well, it doesn't seem like there are a lot of questions, so we will to wrap up early here and let everybody,
one more.
I think, yeah.
Sorry. Would you sponsor a bill if one is written to change the supervision law?
I mean, I will have to look at that and my other priorities for the session. I haven't even started to think about next year yet. I know I have 1412 and 1282 still and 1293 that didn't pass. I haven't really considered all of the bills for next session yet, but we could talk about it.
There you go. I have a question. What is it that we can do as, individuals to help advocate and push that 1412? And what can we do as, we can talk and we can do this and that, but what can we do as we're moving on and moving forward?
Yeah, I think 1412 is not as hotly contested as getting rid of the sex offender registry. That is way more contested because people have a narrative in their mind about who people with sex offenses are. And, 1412, I think really does have a good chance for next year. What I would say is, I know that Kelly, I think, is going to be organizing a coalition. And so, that will hopefully will grow it and we'll get more people involved and more people willing to share their voices and their stories and meet with their legislators. And so you have more legislators who become educated about the issue and will be, prioritizing that. So the work is going to start. And I know that Kelly is excited to start doing more outreach and getting more people involved.
Thank you.
Mm-hmm.
Trying to see if there was a question in the chat that not seeing one. Okay, I think unless again we'll get call for questions, otherwise we'll call it a evening.
Kelly, my wife is sitting here saying that Joanne, talking about she has been attending a trial this week, a net nanny trial, victimless crime, sex crime, and it's a young kid, 22 years old, and it is just so amazing. We are learning so much about these things that are going on, and it is so amazing what we hear in the courtrooms, the lies of the officers and stuff. And I'm just wondering if is there ever any talk about the courts and their misuse of their powers? I'm not sure I worded that correctly, but I think you know where I'm going. A lot of innocent people get put in jail. Is that for another day?
Probably, unless Tara or Nick or somebody has it.
I would say, criminal defense, Washington Defender Association, WACDL are definitely in those, working on those issues. So is, the Innocence Project, like we did pass a bill this session for you're saying wrongfully convicted folks to make sure that any interrogations are video recorded. So that was, I can't remember the bill number, but we did pass that bill, which is great. And I know that we got a study for the net nanny stuff, right? So we did get a study in the budget to look at net nanny particularly, and Representative Sen is working with you all closely to really try to stop, Washington State Patrol from doing those and using any kind of state funding. And there's definitely movement on the net nanny stuff.
I just wanted to say quickly, thank you so much, Tara, because through a 2-week trial for this young man who's been in solitary confinement for 26 months. He was a soldier at Fort Lewis, giving his time and life to be in the military. And it's really horrible what they're doing to him and what they're saying about him, because it's not the truth. It's, you know, it's fabricated and it's a manufactured crime. Anyway, I'm sorry to get emotional, but I'm so glad that we're able to do that study, and thank you for your support.
Yeah, it's just that we're noticing in the courtrooms, we see prosecutorial misconduct and they're never held accountable. And that's, I guess, one of the issues I'm suggesting be looked at. But I'm done. Bye.
No worries, no worries. There's a lot of pain in this whole, system. I wish I could call it a justice system. It's not. There's a lot of pain, a lot of stories, a lot of issues, and we just keep working at it the most we can. But there are ways if prosecutors are not following their rules of professional conduct, that criminal defense lawyers can appeal. But sometimes access to justice is so hard to find. It's so hard to find, public defenders that will take these cases and call out the prosecutorial misconduct, because our indigent defense system is underfunded. These issues are big, yeah. But I appreciate your voice and your stories and showing up in the way you do.
Okay.
So my name is Chevy. I just got done doing 23 piece. And as I was getting out, I went to Evergreen. Actually went to get my degree for sociology, social justice. So as I'm finishing that out, I'm now looking to try and jump in and help a little bit more in some of these directions, because I kind of want to focus on reentry. So this is my first meeting on this. LFOs actually does impact me also. My principal is 7,300. The interest is 24,000 because of how it's racked up over that time. So hopefully we'll be getting that taken care of. But yeah, anything I can do at some point, like we'll connect or get a hold of me at some point. I'd like to be able to help further along towards that and rehabilitation. I know sometimes it just comes down to numbers and people willing to stand up. So at least on that, yeah. And if I still got to turn and apologize.
Yeah. Go ahead and reach out to us. I can put my email in the chat, or you can go to our website and see if I can spell and same time. And reach us. We have game changer work that we're doing. Thank you. If you want to reach out to us, we can see how we might be able to connect with you.
All right, cool. Thank you.
Yeah. Welcome home and congrats.
And I don't know if you've got like a listserv, a monthly newsletter, anything like that that would kind of help those of us on the other side of the state know what's going on so that we can better participate, but also know about the issues. Because sometimes great things are happening on the west side and sometimes we don't always hear about it.
Yeah, we had started at the beginning of session a direct impacted legislative caucus where we were meeting every week, every Monday night. The group of us meeting anywhere from 50 to 40 people were going through what was going on. We're going to take a break for a month, but we're going to revisit it weekly education interim. But we did partner with over in Spokane. Do that. So if you want to find out more about those, go ahead and give us an email.
Okay, because I think you've been talking with Camarina in the Way to Justice, and she had contacted me and said, hey, do you want to get involved? I said, absolutely. Now, how can I do that?
Well, one would be to start if you wanted to reach out to us, and Corey put some links there too about our Facebook group. And we There is I would follow Corey's links to get set up. But we are working on trying to be able to have a little more routine and our sharing information goes. So we're looking at new to do that on full December. And so we're building our team. We're building it as we go. And so those are all good suggestions, I think, to work on.
Yeah, folks, if you'd like to get involved, we have our game changer groups, and we have them in Thurston County, Kitsap County, Pierce County, and Kitsap County. But the great thing is we're on Zoom right now, so it doesn't matter where you are. You can join any group. And if you email, my email is in there, Corey Walster at civilsurvival.org. But the easy one to remember is info@civilsurvival.org. Just email us there and say you want to learn more about our game changer groups and how to be involved.
Got it. Thank you.
Okay, I think for the last time, we'll go ahead and call it a night. And thank you all for being here. And day 2, we have work to do, and it's going to take all of us.
Thanks all.
Thank you very much.
Thank you.
Thank
Take
you.
care.
Bye, everybody. Thanks.
Thank you, everybody. Very informative.
Thanks for being here.